Welcome to the last episode of the terminologies used in court from Court Helicopter. We are dealing with the letter T. The first there is the word testimony. Testimony is the evidence. The evidence that you give in court. The testimony can be oral, the testimony can be written. So that ile ushahidi unaleta kotini ndio inaitwa testimony. Two, we have what you call transfer. The transfer is a term where magistrates can be transferred, where a matter can be transferred from one court to another and other issues. Trial. The word trial means the whole process from when the matter starts landing in court until the end. It is called a trial. Undertaking. An undertaking is when an advocate says, I am going to, just like a surety. In conveyancing matters, you get your money, you give to your lawyer. The lawyer gives an undertaking to another person that I have the money, you give him the land. Once you make the title deed, I shall provide an undertaking. An undertaking is very, very critical in transactions all over. A bank can give an undertaking. When Waititu was released on bond, he was told to bring a bank guarantee. The bank guarantee of 53 million shillings. That is what you call an undertaking. So, don't undertake on behalf of somebody who you don't understand. Don't stand surety on somebody you don't understand. Letter V. We start the word vacate. This is where orders exist. The court has given some orders. You challenge those orders either in the same court or the other court. So you are vacating those orders. For example, they declared this land belongs to Nyakenyo Women's Group. You move to court and produce proper title deeds and say, vacate now these orders. So vacating of the orders is removing that which was there previously and returning it to the way it was. Verdict. The verdict is the decision of the judge. The verdict is, remember, in court, it is a contestation between 2 or 3 people. A magistrate, a judge makes a decision. That decision is called a verdict. It is called a judgment. It is when you are convicted, that is a verdict. When you are acquitted, released, that is a verdict. When the court makes the decision, when it upholds the impeachment of Gachagua, that is a verdict. When they uphold the elections of Dr. William Samoei Ruto against the late Raila Odinga, that is a verdict. That is a decision. So, it is only verdicts that you can challenge to higher courts. Then we have what is called a voir dire test. A voir dire test is a test where the court, especially in children matters or very old people, the court wants to test whether are these people understanding what is going in court. Are they mature mentally? Are they are they intellectually alert? So the court will ask the child, what is your name? Which school do you go to? What did you eat in the morning? Do you know where you are? Yes. Is it in court? Yes. What? So that voir dire test is very critical to test whether somebody is alert to proceed with the matter. Letter W, which is the last one in this matter, we have the warrant. A warrant is a warrant of arrest. A warrant of arrest is when somebody fails to come to court, then they will issue a warrant of arrest. They will come, arrest you, and bring you before the court. Another warrant is a warrant of search. When the police want to come and search your compound, your house, they will get a search warrant. They'll come, knock, they'll identify themselves, they'll do a search and carry whatever they want to do. So that is a search warrant. When they want to get access to your account, to your phone, they'll do a search, they'll get a warrant to access your phone and open up and get data from there. So the warrants are many depending on what the issue is. Then we have what is called a witness. A witness is the person who comes to give evidence. That person is called a witness. Then we have a term called without prejudice. Without prejudice. What does the word without prejudice mean? That some communications are not going to be used in court as evidence. What we have talked is without prejudice. Some information is not admissible in court. And lastly, the term a writ. A writ is a declaration of a court. We have what is called the writ of habeas corpus. The writ of habeas corpus is when somebody goes missing, you go to court. For example, during the Gen Z demonstrations, there are people who disappeared. You go to the High Court to look for what is called a writ of habeas corpus to produce the missing person alive or dead. Bring that person in court alive or dead. That is called a writ of habeas corpus. I think Court Helicopter has given you the most elaborate education on terminologies of court. Why do you miss it? Don't mind. We don't charge. We are always available to give to the community as CSR knowledge of the law. Always be tuned in. Every Saturday, every Sunday, we give you Court Explainer. And over the festive seasons, all the festive seasons, we will take you through the Constitution of Kenya. Keep glued when we start the episode that will bring you more than you want from Court Helicopter. Keep watching, keep tuning. Wakili Danstan Omari. Thank you very much.